And now we'll begin our fifth session of the week, Open Meeting Law and Anatomy of a Meeting. Our speaker this morning is Christina Estes-Werther. Christina is of counsel at Pierce Coleman, PLLC. Christina's public law practice includes matters involving open meeting law, conflict of interest, public records, land use, government contracts, and state legislation. As the former state election director for the state of Arizona and a current certified election officer, Christina has extensive experience in election law, including campaign finance and election administration. She most recently served as general counsel to the League of Arizona Cities and Towns. She just switched over to Pierce Coleman, so we're still missing her, even though it's only been a week. When she was general counsel for us, she provided technical assistance to league members, legal research to municipal attorneys, and conducted a number of regular trainings to elected officials and municipal staff. And she's done this training for us for a number of years. Christina received her JD from Gonzaga University School of Law in Spokane, Washington, and began her legal career as the Judiciary Committee analyst in the Arizona State Senate, and subsequently held the position of policy advisor and deputy counsel for the Office of the Governor. With that, please welcome Christina Estes-Werther. Christina.
Great, thank you, Matt, and hello, everyone. This is actually one of my favorite trainings. I'm so sorry that we can't be all together in person because it's always so nice to actually meet all the newly elected officials. So today we're going to be talking about anatomy of a council meeting and the open meeting law. So these are kind of some hefty subjects. So we're going to kind of go just piece by piece through them. And as Matt said, please feel free to kind of type in your questions and we'll try to make sure we get all of those answered. So I'll go ahead and jump in. So just to give you an overview of what we're going to be talking about. So we're going to be discussing kind of an introduction of just the laws, the rules, procedures, everything that has to do with kind of your role as a council member and just sort of your conduct and what the public's role is. And this is intended to just be an overview. There's a lot of nuances, and sometimes you actually really need to go back to your own local procedures to see if you have anything that's just more suited for your jurisdiction. And again, if questions aren't answered today, hopefully we get them all. You can please always contact the league, and then also my contact information is at the on the final slide. So first, we're going to talk about anatomy of a council meeting. So we'll have probably about 10 to 12 slides on this issue, and then we'll go into the open meeting law. So we're going to just touch on it here, but I just kind of wanted to give you a little bit of an idea of kind of where we're going. So your council meetings, so of course the purpose of your meetings is really to transact the business of the city or town. It's to let the public know what it is you're doing and to hear input from them as well. So governing law. So basically, what is it that guides you as a member of the council? So you have your state law, you have procedural rules, and in those you have sort of three facets. So you have your local rules of procedure. And again, a lot of cities and towns kind of have their own specific rules, again, to kind of best suit their jurisdiction. And then you also have maybe parliamentary rules. And these are rules that conduct, your business at the public meeting. And then we'll talk a little bit about common sense and courtesy rules, known as Riggins rules. So first, I just wanted to touch on the state law. So I did include the open meeting law here, but again, we're going to go into it much more in depth later. So the open meeting law is essentially a state law that requires that your meetings have to be open and public and transparent, and they have to be physically accessible to the public. And so, again, we're going to talk about this more later, but this is really going to be a very important, piece of information as you move forward about how you actually conduct your meetings and what you can do to make sure that you don't run afoul of the law and that you don't commit any violations. So we'll go much more in depth about that. I also wanted to touch on just the state law that talks about quorum and voting. So we have a Title IX statute, which is our cities and town statutes, that basically says a quorum is just a majority of your membership. And that's what's required for any type of action. Now, sometimes you might have situations that actually require a supermajority. So maybe it's a 2/3 or a 3/4, depending on that situation. And so that's something that you will be informed about kind of for that specific meeting. Usually there's a notice for, on there that someone will kind of inform you about it, or perhaps, the clerk or the attorney is going to let you know that it's a supermajority that's required. And then they'll let you know how many votes are required for that specific issue, whether it's a zoning, protest, or an emergency clause situation. So again, supermajority is calculated based on membership and not on the members present, but you're going to get that specific guidance in those cases from your city or town. Otherwise, just default to your quorum is just a majority of the membership. Also, I just wanted to mention conflict of interest. So this is something we get a lot of questions about this. What is a conflict and what do you have to do? What are the steps if you actually have to declare a conflict? So I'm not going to go too much in depth in this also, because I know you're going to get another training, your ethics training later today. And Bill's going to talk much more in depth about the conflict of interest statute. But again, it is a governing law for you as a council member that I want you to be aware of. And I also just wanted to emphasize, people get very concerned when they hear that, someone might have a conflict. So conflicts themselves are not inherently bad. People have conflicts because they have relationships with individuals or businesses. So having a conflict in itself is not a bad thing. I think potential for a violation occurs when you have a conflict and you fail to disclose it, or you don't recuse yourself from participation in that discussion or vote. That's when you can sort of run into a violation, but having a conflict is not necessarily a violation. It's really the steps that you take or don't take that then can lead to that error. So it's a pretty fact-intensive assessment. It's a case by case, kind of situation, looking at what the law requires versus what the facts are in your situation. So that's why you typically need some guidance from your legal counsel when you're perhaps facing a conflict and trying to determine whether or not you need to disclose and recuse yourself. So we do have a publication. The league has You as a Public Official that has more information. But again, Bill's going to talk about this much more in depth later today. Okay, so that was just sort of, again, highlights of the state law. So these are procedures. So procedures are either council adopted local rules of procedure. Again, maybe your jurisdiction has adopted some rules. There's also common sense rules, and then parliamentary procedures. So let's talk about your local rules. You're going to want to ask again, sort of maybe your other fellow council members or your clerk or your attorney or your manager of, hey, do we have our own procedural rules? And reason that people do this is because sometimes the parliamentary rules that are out there don't necessarily fit for your city or town. And so you can actually tailor them to fit how your council operates. And so make sure that you ask to see if you have any local rules of procedure. So the next is sort of the common sense and courtesy type of rules. And these are ones that, of course, I think most of you are going to be familiar with. Sort of just the best practices of, sort of how you treat people, how you treat the public. So we'll kind of run through these. And so we have two columns here, a do and a don't. So first, of course, is do your homework. And these rules were actually put together by Fred Riggins. He was a planning commissioner for the city of Phoenix. And then they've kind of sort of gone national. So these are, again, seen as best practices. So the do your homework is really about just being prepared. You're going to get agenda packets ahead of time or materials or information before your council meeting. You're going to want to make sure you've read that. Doesn't mean that you have to understand everything that's contained in there. That's what's going to be discussed at the actual council meeting itself if you have questions. But you want to make sure that you've actually read the material so that way you can go ahead and make those informed decisions at the time of the council meeting. You also want to, of course, be on time. So this is not just a courtesy, but it's also helpful for quorum purposes. So essentially, if you're a 7-member council, you need 4 as a quorum to start your meeting. So if several members are late, then that's essentially holding up the meeting, not only for the members, but also for the public. Also dress appropriately. Of course, you just want to make sure that you're dressing for the role that you have, because you're really in the eye of the public, not only in person, but nowadays most of our councils are meeting either virtually or if they're They're in person, it's still being streamed live. And so you just want to make sure that you are presenting your best self. Also be polite and impartial, and that goes really for everybody, not only your fellow council members, but of course members of the public and the staff. You don't want to show favoritism to sort of one side or another. Also, be attentive, just make sure that you're listening. And we'll talk a little bit more about this in the open meeting law. You don't necessarily want to look like you are taking text messages during a discussion, or that maybe you're sort of whispering or talking quietly to other council members. That can sort of lead to the perception that you actually might be violating the law. So, you just want to be attentive and listen to the conversation that's occurring at the council meeting. Also, make sure you're consistently using titles of respect, just for, again, all members of the public, all members of council. And you want to be objective as you're listening to the information that's being presented to you. And then also invite public participation. So again, this is at designated times. You might have a call to the public. And so if you do, that's when it's appropriate for the public to come and comment. Often there's, time limitations, and that's fine. But you just want to make sure that you're inviting the public at those designated times. And then also respect the staff work. So you have a lot of people that put things together in order for you to be able to do your job. And so you just want to make sure that you give them the appropriate respect. And then sort of in the don't column, you don't want to get personal. And this can be difficult when you actually if you have a call to the public and you have members of the public who are criticizing you, which, they're free to do, but you have limitations on how you can respond. And again, we'll talk a little bit more about that later. But, I think it's just a good rule of thumb that you just don't want to get personal in your response back. And then you just don't want to try to make anyone look bad, don't show anybody up. You don't want to interrupt. Part of this has to do with your parliamentary rules as well. Everything has to go through your chair because that's how you have a kind of properly run meeting. If you start talking over one another, again, that just sort of defeats the purpose. Nobody can hear anything. So you just want to make sure not to interrupt. And then you don't want to permit speaking from the audience. Again, the public, if you have a call to the public, will have a designated time to speak. You don't want to encourage the audience members or the members of the public from speaking out of turn. And sometimes this can be seen as applause, or any types of like yelling or, shouting, that type of thing. You really want to, if you're not the chairman, you want to sort of help support the chairman in making sure that gets under control. Because again, it just disrupts the meeting to the point where it doesn't help anybody if no one can hear each other. Also, you don't want to answer technical questions. And so this can be hard. Speaking as an attorney, and if you happen to be an attorney on the council, remember that you are not the legal counsel for that public body, right? So of course you have your expertise and your knowledge, and you can use that to make your own informed decision and even share your thoughts during your explanation of votes or discussions and deliberations. But you certainly have to kind of remember what your role is, and you are there as the policy maker. So same thing goes, of course, for any background, whether or not you're a realtor or you're an engineer, anything like that. You're usually, as the council and the staff, is bringing in these technical experts on certain issues. So this kind of goes along with the respect. You want to make sure that you're actually listening to them, hearing what they have to say. Certainly, again, you can share sort of your background and knowledge, but you don't want to sort of answer for them if they're the ones who are presenting the information to you. Also, you don't want to allow, again, two speakers at once. You just want to make sure for that sort of parliamentary and protocol that everything is going through the chairman. They're giving the permission to speak. And then at that point, it allows for like a properly run meeting so everybody can have an equal chance to be heard. So those are just sort of those do's and don'ts, kind of common sense. I think most people follow them. So parliamentary rules. So these are just rules, again, for conducting business at public meeting. It allows the public to hear from all the council members. It just helps for everything to run more efficiently. So debate and decorum are very important in any type of public body meeting. Again, the speakers have to be recognized by the chair before they speak. And it can be a little awkward at times if you've never done it, to be like, Mr. Chairman or Madam Chairman, before you speak, you have to get permission to speak. but it becomes sort of commonplace, and it becomes, you'll fit right in once you do it several times. Um, and then comments again are just addressed to the chair and then to the council. And then debate just has to be confined to the issue, right? So you can't start then maybe talking about things that aren't on the agenda. Again, this is more of an open meeting law kind of issue that we'll talk about later. But whatever items are on the agenda is really all you can discuss. You can't discuss some other issue that isn't listed or posted on the agenda. If you want to talk about that, then you need to get that posted on the next agenda. So debate has to just be confined to the issue before the council. And then debate, you just want to avoid personalities, again, just be objective and neutral and, kind of fact finding, but you don't want to, again, make it personal. And then council procedures, and this is where you're going to want to look in your local procedures. They may restrict how many times a council member may speak on a motion. Um, Otherwise, there sometimes it can just go on and on. And so sometimes there's some limitations that are put in by various jurisdictions to kind of limit how many times someone can speak. Not always, though, so you'll have to check. And then questions or subjects are not debate, because debate is really just what you're speaking, your comments on the motion. It's not really a time for questions or suggestions. So a lot of this can get really confusing at times, but again, it's just really more practice. I think that's the one thing I've learned over the years, that you'll get through it after a few council meetings. You're going to understand, and it's going to become second nature to you. So don't fret too much if you're a little bit worried about how all this works. And your fellow council members, especially those who've already served for a while, they can help you through it. It's not, it's fine if you're like, I don't remember how to make this motion, or I'm sorry, I forgot to go through the chair. I mean, those types of things happen, and then you just correct it and you move on. So I've mentioned a few times about parliamentary rules. So the one that people use the most is the Robert's Rules of Order. And so this is a pretty hefty manual, I guess I would say. I actually have a copy here. It's like this little tiny book, but it's pretty thick and it's all very small print. So you may or may not follow this, or you may follow a modified version. That's why it's important, again, to ask what your local rules are. But Robert's Rules of Order are used a lot because they help sort of prioritize the motions that you use, when you can make them, how do you rescind something maybe you voted on, how do you reconsider an issue, and then how to postpone. So that's just some of the items that kind of covers. And then for motions specifically, so motions is just, a formal proposal that certain action be taken. And so again, sometimes people struggle with the language of making a motion, but it's really just the actual action you want to be taking, and then kind of saying I motion or I move, and then the action at that point. So again, you get better at it as you go along. Motions are only made by council members, not the public. A motion always requires a second. So if someone makes a motion and there is no second, then that motion doesn't go anywhere. It doesn't go for discussion. It doesn't go for a vote. It just sort of dies. Now, seconding a motion does not indicate an endorsement of the motion. And this is really important because sometimes some people aren't, maybe they're not in favor of the actual underlying decision that might be made. But again, for parliamentary procedures, in order to get to the discussion phase, someone needs sometimes to second it. And so just because you second it doesn't mean that you're indicating that you're going to vote yes for that particular motion if it gets to a vote. So I have a couple examples here of a motion, an amended motion, and a substitute motion, just so you understand kind of basically how it works. So let's say you have a motion, there's an agenda item that talks about, perhaps building a wall. And so someone says, well, I want to build a brick wall. And so it says, okay, well, then I move, we build a brick wall. So that's a motion that someone makes. Again, you need a second to actually make that into a discussion and deliberation. And then you can then go vote on it. So that's the original underlying motion. So let's talk about an amended motion. So what about when you're having that discussion and someone says, I move that we, build a brick wall, and then you're having your discussion about it. Someone's like, yeah, but that's not going to be sufficient to, cover this piece of land. And so I move we build a brick wall at double the size. And so then you're actually amending the underlying motion. So you're not substituting it, you're just adding to it. So you're retaining the original motion, but you're making some changes. Now that amended motion also has to have a second. And so if you do get a second on that amendment, then the goes to a discussion and then it goes to a vote. And if you vote yes, and so the amendment passes, you still have to go back and actually vote on the motion as amended. So it's almost kind of like a first step. You just basically amended the first part and you've passed it, and then you still have to go back and amend the motion itself. So again, it sounds really confusing, but you'll do it one or two times and you'll pick up on it really quickly. And this differs from a substitute motion, which is that you're actually changing it completely. The underlying motion is sort of going away. So instead of that brick wall, someone says, you know what, I move a substitute motion that we build a picket fence. And so now again, completely different from the original motion. Now this substitute motion again needs a second, and then you have a discussion. And then during that discussion, then you can move to the vote. Now, if the vote fails, let's say you don't have enough votes for that substitute motion, then you go right back to the underlying motion about building a brick wall. But if the substitute motion passes, then it supersedes essentially, and that underlying motion, the brick wall kind of disappears. It's just like it never happened. So you don't have to go back to that. And so the substitute motion will be the one that carries and that's passed and moves forward. So there's just some distinctions about kind of how you do the motions. But again, staff are always there to help you out. So, I've been through a number of committees when I was in the legislature and with new members. And again, you can just ask for help. So even though it sounds very formal, if you're like, I forgot how to do this, or how do I do this, someone can whether a council member or a staff member can help you with it. And again, you will pick it up right away. Like third or fourth council meeting, you're going to have this down. So don't worry. So some common motions, we kind of talked about the one motion to adopt, which is essentially, you have your action item and you're just moving it, but you also might want to adopt reports or anything like that. A motion to reconsider is essentially maybe you're having, heartburn or immediate regret about something that you just voted on. And again, you have to be on the prevailing side. So let's say it was a vote for that picket fence, and then it passed, and then you're like, oh, you know what? Maybe I do want the brick wall instead. And you were on the prevailing side, and so then you can make a motion to reconsider. And basically that will just get back on the agenda for you to vote, all of you to vote again. Now, this is where it's a little bit tricky about your procedural rules. So you need to check if you have local rules. So Robert's Rules of Order has a very specific way about how motion to reconsiders are handled, but you might have something in your procedure rules that says that maybe the motion has to be done right then at the same time, like at that same meeting, and maybe the motion to reconsider has to be heard right then at that same meeting, or maybe it has to be at the next meeting. So just make sure you understand the rules about reconsideration. Another common motion is call for the question. And that's essentially, you're just cutting off debate. So maybe if something's going on fairly long and you everyone's opinions and discussions are kind of, going, being repeated over and over, and you just want to get to the vote, you can call for the question. Of course, you just want to make sure you use this, carefully. You don't want to just use this all the time. You want to make sure people do have an opportunity to actually debate. Motion to postpone consideration, that's just again to kind of continue an item for later. Motion to suspend the rules. I've seen this most often with the examples here, which is speaker time or meeting time limit. So maybe for some reason, you have a designated that every speaker has about 5 minutes to speak, a member of the public, but then you have a big issue on the agenda that it looks like, you have, 100 people show up to speak on a particular issue that might be controversial. And so perhaps you want to lessen that to 3 minutes. And so if that's in your rules, then you would have to motion to suspend rules and pass that in order to then reduce that time limit. So that's just an example. So a motion passes if a majority of those present vote for it. Again, if you have a supermajority requirement, there may be other, other votes that you have to consider. A tie vote means that the motion fails. And then abstentions are counted and noted, but they're not usually listed again as yes or no. So this is where, again, you check your local rules to see how they deal with abstentions. And then votes can be done by roll call or voice vote. But we are going to talk a little bit about in the open meeting law that a new law passed a couple years ago requires that you have to at least know, like there has to be a record of how each council member has actually voted. So voice votes are okay for things that probably are going to be like on the consent agendas, things like that, that aren't going to have too much of a problem. You're probably going to get a unanimous vote. But if it's something where you might be having, obviously different votes, you might want to just do a roll call. So it's very clear about which members have voted on which issue. Okay, so now we're just to the Q&A. And again, open meeting law issues we're going to talk about as in the next sort of phase of the training. So this is really just going to be focusing on this first piece.
All right, Christina, we do have a few questions. The first question is, do adopted procedural rules supersede parliamentary procedure?
Yes, so there is no state law that requires you to have like a parliamentary procedure. So again, that's really just for you to be able to conduct the business. And so certainly you can adopt, the Roberts rules or Mason's rules, or you can adopt your own local procedures to help you.
Okay, great. Next question. What if there is no mayor or vice mayor present to run the meeting, but there is a quorum? What happens then?
That's a good question. Well, hopefully if that would be known ahead of time, and so perhaps someone would be designated. I don't know if there's probably the most senior person there might take it. I don't know. I think Tom's jumping on, so I don't know. Okay.
Yeah.
So
I think
that's a good question. I don't know that there's a specific procedure for that. That actually might be something that's outlined in your procedures themselves. It's sort of like, the process of who actually would kind of rank next as taking. But I would assume probably the next senior council member.
got it. So, but they can still run the meeting if they have that quorum, even though there's no mayor or vice mayor.
Correct. Yes. Yes. If you have a quorum, you can have the meeting.
Okay, the next question is, what if the topic is not on the agenda, but is directly related to the topic on the agenda?
Well, I would say be very careful about agenda items because kind of as we'll kind of talk about it in the open meeting law section a little more, but you want to really be clear that it is on the agenda item. It can't be something sort of tangential because that's pretty clear open meeting law violation. So if you're concerned about how it's worded, that maybe something on the agenda is just too narrow and you think it's going to, limit discussion, then maybe you can talk about sort of broadening it. But you want to stick to what's actually on the agenda.
Okay, next question. Does a friendly amendment require a second?
Yes, so any amendment, any motion, it always requires a second.
Okay, next question. Does calling the question require a vote on calling it before you move to a vote on the main motion?
No. So call the question is just simply that. It's basically a mechanism to end debate and to get to the vote. So that's why you just want to be careful about how you use it. You certainly want to make sure you allow people the opportunity to debate.
All right, the next question is related. Can any council member call for the question or just the chair?
Again, unless your local procedures say something different, the Roberts rules is that anybody can call for the question.
Next question is, please describe a situation in which a council would vote to suspend the rules.
Okay, well, I think we talked a little bit about sort of, again, the time limit one is the one I've seen, I guess, the most often, which is, again, maybe if you have something in place in your local procedures that say you always give the public, 5 minutes to speak, on a specific issue, but because of the amount of people there that you want to have actually less time, otherwise you'll be there, 24 hours or something, then you might have to then go ahead and take the vote to suspend the rules. So that way then you can limit the time to maybe less than 5. So that's the one I've seen the most often. Again, you have to actually have some rules in place in order to suspend. So if you don't have any written, rules on a particular topic, then with this parliamentary procedures, you have some flexibility and you may not actually have to suspend rules.
Right. The next question is, if you have an abstention and the vote is 3-3, what happens?
So that's a good question. So that partly also depends on your local procedures. For essentially for Robert's rules, I mean, if someone is abstained, then that's and you have that situation, it would fail. That's still essentially a tie. But you would want to just see if anything in your own procedures kind of supersedes the Robert's rules.
And then the second part of that question is, can you quickly review how an amended motion is handled? What happens to the original motion?
Okay, so if you have an original motion, it's still there. So if you're amending it, you're just basically adding to or modifying the original motion, and so it doesn't go away. So you have your motion and you've seconded it, you're having a discussion, and then someone says, "Well, I like that idea, but I just want to make a modification to it," and so that's when then you'd make an amendment. And that would be seconded, and you could have that discussion on the amendment. And if you vote and pass that amendment, then you just need to go back and say, okay, now we just need to vote on the motion as amended, sort of the whole package. You're kind of tying it all up in a bow, but you're not changing, you're not substituting, right? You still have components of the underlying motion, and you're just making some modifications to it.
Right. Next question is, can you explain supermajority in zoning disputes?
Well, I can just touch on that you have to see what the actual requirement is for your voting. So it's just a higher threshold essentially. So typically for a lot of your votes, it's just going to be majority. So you're going to just need, if it's again, 7 council members, then you just need 4. But for, your zoning or anything like that has a higher threshold, you're just going to need more of them. So you maybe might need 6. It just depends on what the actual law requires. For zoning or for emergency clauses, sometimes they differ. And so again, the clerk or the manager or the attorney, they'll let you know as you're obviously voting, like, hey, this is a supermajority, you're going to need this many votes. And so all that's kind of spelled out to you ahead of time.
Okay, the next question is, can discussion on an agenda item happen if a motion hasn't been provided?
So again, this is one of those where it depends on how your procedures are laid out. I have seen that happen, and that's fine. You're just basically though having a lot of discussion on something that may not actually go anywhere. So I think that's why most tend to actually put the motion first, make sure there's a second. So that way, then at least you're discussing something where there's kind of been some buy-in that everybody is ready to actually discuss and possibly vote. Otherwise, you might be having a very lengthy discussion and then you get to the motion and there's no second and it fails and you're not even getting to a vote and you've just essentially had all this time on an item that was not going to go anywhere. So I think most tend to just do the motion and the second first.
Great. Next question is, who is responsible for maintaining order? For example, if a council member rips into the staff publicly.
Well, first you have to always go through the chairman, right? So whether it's the mayor, vice mayor, whoever's managing that meeting, they're the ones who are giving you permission to speak. But at again, this is just about proper decorum. I think we're all sort of individually responsible for making sure that we're treating everybody with respect. I think I'm not sure that it's really anybody's sort of specific responsibility to sort of call out another council member. Obviously there might be some discussions behind the scenes afterwards, that type of thing. But everybody on the council is free to make their own, I guess, comments about, how they appreciate staff and encourage, them to provide the information to them. So, there's, I think, multiple ways to do it, but I wouldn't say that it's sort of on one person to actually have to sort of manage the behavior of others.
Thanks. Okay, the next is a comment. Somebody said their computer shut down and they just wanted to know if we're going to be sending these sessions via email. Yes, as I mentioned, we'll send you all of these videos It will probably be next week, but all those who signed up for the newly elected officials will receive these videos. So you will have a chance to rewatch them and share them if you would like. Okay, the next question is, what happens if council gets confused and passes an amended motion, but not the original motion?
Well, first, your staff should be there to help you with this process. So you'll pass your basically your amendment, and then you'll pass your amendment to the motion as one package. So it's almost kind of like if you just have one amendment, there's essentially two votes. You're voting on the amendment, and then you're voting on the motion as amended. So there should be staff there to kind of help you walk through that process. If it looks like you're going to sort of move away to a different item before you fully voted. Because I've been in that position in the staff role where, you get on and you start discussing things and then you forget that you haven't done the underlying. And I've had to stop and raise my hand and make sure that they know that they have to finish completing that action. So, you kind of help each other out, and then also the staff will assist you.
Okay, thank you. The next question said there was an incorrect answer on call the question. In Robert's rules, it says it requires a second and a 2/3 vote.
Well, I'll have to double check on that, but I know that that's not how we've done it in the past. But certainly, if you have the Roberts rules in front of you, and if you want to follow that, and does not conflict with your local procedures, then certainly follow what it is that you've been designated.
Yeah, but it's a good point too, Christina, that the local procedures supersedes Robert's rules.
Yeah.
So,
Yes.
Okay, is there a preferred way to remind a council member about the quorum, or should it fly? And are members of the staff ever allowed to speak up about something besides being called upon by the council or the town manager?
So I guess with the quorum question, I mean, you can't start the meeting until you have the quorum.
No, decorum. She says, is there a preferred way to remind a council member about decorum?
Oh, decorum. Okay, sorry.
Yeah, yeah.
So I think a lot of cities and towns have sort of like overview of policies and procedures. Kind of like ethics, review, again, sort of best practices of that type of decorum. So hopefully that's something in there that you might have some mechanisms to be able to help. If a council member is struggling with that. Um, and then what was the second question, Matt? I'm sorry.
It was, are members of the staff ever allowed to speak up about something besides being called upon by the council or the town manager?
Well, I mean, I think most of the time they pretty much, defer obviously to the council and are there if they are needed. Again, sort of that example that somebody asked about, if somehow the council is moving away from an item and they haven't fully voted, then yes, I mean, the clerk or the attorney, someone will probably stand up and say, or raise their hand to get your attention that you need to complete that motion and take that vote. Or maybe sometimes they might do that if they have something that indicate to you that they have something to share on a particular item that you might be struggling with. But aside from that, they pretty much wait to be called upon.
And this was somebody saying that they didn't understand the answer. And the question again is, do you need to vote on ending discussion under a called question, or does someone just say, call the question and the discussion ends?
Well, so typically, again, the way that I've seen it is that you call the question and then you just then go to the votes. Because again, the call to the question is happened after usually a lengthy debate. So you already have a motion, you have a second, you've been having discussions and deliberations. And so then someone calls the question. And so you're just kind of accelerating to the vote. So then you're getting to the vote and everybody obviously takes the vote, it passes or it fails. So that's pretty much typically how it works. But again, check your procedures just to make sure that how it works in your specific jurisdiction.
Okay, the next question is, if a city doesn't have their own procedures, is it assumed that Robert's rules should be followed?
Not necessarily. There are other parliamentary rules out there. Like the legislature follows the Masons parliamentary rules. And so, that's just something you're going to want to check with your manager or your clerk.
Okay. This next question is, when does the maker of the original motion need to agree? when there's an amendment, addition, etc. to the original motion?
So the maker of the underlying motion doesn't really have to agree if an amendment is offered. So you could have sort of council member A, who was the original, they made the underlying motion, someone seconded it, and then someone decided to add an amendment, council member B, to have an amendment, and then they got a second from a fourth council member. That doesn't require sort of any permission from council member A, the originator of the original motion. They'll have sort of their say when they vote on the amendment.
Okay. Can you replace a motion even if you didn't propose the original motion?
Yes, so I think that maybe they're talking about amendment or substitute. So any council member can make a motion to amend or substitute.
Okay, and then somebody else just said they think that under Robert's rules, the calling the question is not correct, or didn't answer the question about, says, I don't think the answer about calling the question is correct under Robert's rules.
Okay. Well, I'm not sure which answer, if that if they're referring to. But we can definitely check on the call to the question, and I'm happy to like send something out to you, Matt, if you want to send it out to everybody. But
Great.
again, this is only going to be Robert's rules and not necessarily maybe your specific rules.
Great. Okay, there's a few more questions and then we'll move on, just because we have the open meeting law, which there's a lot there. But we'll come back to any questions we don't get, we'll come back to at the end. The next question is, for a substitute motion, can you, for example, substitute the brick wall motion for a new fire department building, or does the substitute motion have to be somewhat similar? I know that some cities have elected to forego the call to the public due to COVID. Is that legally in their authority? So there's two questions there.
Okay, so the for the substitute motion, it actually relate back, I mean, first of all, for the open meeting law, you have to stick to the agenda item. So you can't sort of go off and again, kind of think you said like a fire department building or something. If that wasn't sort of in the agenda item description that you were going to talk about that, then that's not something you can sort of substitute motion when it wasn't actually on the agenda. So typically substitute motions, even though they are different from the underlying motions, they're still on topic. And then I think you said the call to the public. So the call to the public is actually not required. The public has the right to attend and listen to all deliberations, but they don't actually have the right to speak. Most jurisdictions, cities, towns, counties, everybody tends to provide a call to the public. And if you do so, there's certain requirements you have to follow, but the actual call to the public itself is not required.
Okay, the next one is, can the chair deny the request for a call to question if he or she feels more discussion is needed?
So typically you're not supposed to be able to, but I think like I said, with the call to the questions, I think we'll just provide some more information later.
Yeah, I think that makes sense. All right. So we'll do the last question. What do you do if you would like more discussion or delay the vote to another day?
So that's part of, you can postpone or table it. Again, you can make motions basically to ask for that basically. And if you can get a second, then everyone can vote on whether or not they want to postpone that or move that to another, an agenda item for another day.
Okay, great, Christine. I think that's it. The rest of the questions were related to the call to the question. I think we'll
Okay.
do some follow up on that. But those are the questions that we have now, so you can continue.
Okay, great. Well, thanks everyone. We'll get answers to those questions. So next part is open meeting law. So this is something that it's very important for you to know, and it's kind of going to help you guide you as you conduct your meetings. So let's just give you an overview of what we're going to talk about. So the purpose, we're going to talk about what is the open meeting law and why you have to follow it. The definitions and those meeting requirements that are in statute and how it applies to you. And then violations and penalties, who investigates your complaints, and then what happens if you violate the open meeting law. And then we'll have a few slides at the end of just who can you talk to if you have open meeting law questions. Okay, so what is the open meeting law? It's essentially a state law that mandates open deliberations and public proceedings It prohibits public bodies, the councils, from making decisions in secret. So this is just directly from the statute, talks about what is the public policy, of the open meeting law. And it's essentially that, again, they want these council meetings to be conducted openly. They want it transparent. They want notices and agendas and information to be public and accessible. Anytime you have sort of a question of whether or not something might violate the open meeting law, you always want to interpret it in favor of open and public meetings. So this is just a quick slide on some of the history of the open meeting law. And the reason why I include this is just to show you that, first of all, this has been in law since 1962, and it's been amended over the years. And as you can see, sort of every amendment has been to expand or broaden the open meeting law versus, narrowing it or making any type of limitation. So it's expanded the definition of who was included by governing bodies. It's expanded, to again include subcommittees and advisory committees, and then also to include technological devices, which we'll talk about how that impacts you. And then also just recently in 2018, it established some new penalties. So this is a question that's important to you. Why do you have to follow the open meeting law? So as a public official, you obviously have responsibility to abide by the law. You take your oath. Also, the statute grants the public the right to attend and listen and to hear sort of the public business that's being conducted. They don't want these sort of important decisions in their city or town happening behind closed doors. Also, this promotes accountability by encouraging responsible actions, and then also just maintains that relationship of integrity and trust between you and the people that elected you. So what are your responsibilities? So first, the city or town clerk is required by law to conspicuously post open meeting law materials that have been prepared and approved by the Attorney General on your city or town website. And then you are required as a public official to actually review that material at least one day before you take office. Now, it doesn't mean you have to, know everything in there, but you do have to at least review the materials. And most often the cities and towns are posting the Chapter 7 of the agency handbook that's produced by the Attorney General's office. And that's the open meeting law materials that are being provided on the website. So how do I know if the open meeting law applies? So I've kind of broken this down. First, you have to be a public body and you have to be meeting, and that is defined. So first, let's talk about public body. This is the definition in statute. I'm not going to read it, but it encompasses political subdivisions, multi-member governing bodies, and essentially a city or town is a public body. We squarely fit into that definition. And so we can already sort of check the box for that first criteria of a public body. So the question I get most often, because I think it's sort of people understand that the city or town is a public body, is what about sort of our special advisory committees or subcommittees? Are those, a public body under the open meeting law? And so we have sort of 5 basic categories here of public bodies. And as you can see, it does include advisory committees and standing and special committees. And of course, any of the committees kind of listed here. So the distinction in how you kind of determine whether or not an advisory committee or subcommittee is actually subject to the open meeting law is it actually has to be that the council has officially established, that committee or the council itself has established it, and that subcommittee or advisory committee or task force is actually going to come back and make recommendations to the council concerning a decision that then the council will weigh on and probably make its own decision. And so that's what's technically the definition of an advisory or a subcommittee. And so if you have that set up, then yes, any advisory committee or subcommittee is subject to open meeting law, which means those members that are assigned to that subcommittee, it doesn't matter if they're council or not, it could be members of the public. They, again, have to abide by the open meeting law. You're going to have somebody there to, again, post the notices and agenda, same as a council meeting. Someone's going to have to be there to take minutes. You have to record votes. Everything that happens essentially for the council meeting has to happen for the subcommittee as well. Again, if they meet this criteria. So we've had some questions over the years of, does the situation change if the members of council are serving on the subcommittee versus maybe a subcommittee that's made of all public members? And essentially, open meeting law does apply again, regardless of the makeup of the membership. Because again, if you have the council or the mayor that's actually established the committee, and the committee is going to come back and make recommendations to the council, they qualify as a subcommittee under the statute and are subject to the open meeting law. So you do have some situations, though, where maybe there are some types of meetings or groups that are not subject to the open meeting law. And these are things like staff meetings, or maybe a staff appointed committee. Maybe you have a specific department that's looking into an issue. And so that department head forms a group, like a working group, to essentially help them in their reports or recommendations. But that's not a council appointed committee, right? That's something that maybe the staff has actually put together themselves. They would not be subject to the open meeting law. Also, single department heads, they and what they do in their daily work is not subject to open meeting law. So again, the requirement is that the council or the mayor has to actually establish this committee, and then you actually have to have that committee come back and make the recommendation to the council. So you do want to be careful that you're not trying to circumvent, the open meeting law by sort of telling, one of your staff members, hey, form this committee for me. And yes, they're going to come back to the council, or yes, we're going to get the information, but we don't want to go through the hassle of, establishing a subcommittee that's going to be subject to open meeting law. I think if you do that too often, that's obviously going to raise some red flags, that someone might make a complaint to the Attorney General's office. So again, you just want to make sure that if it's something really clearly like staff meetings or single department head meetings, things like that aren't subject to open meeting law, you're safe. But anything else, you're just going to have to make sure that all of those requirements are met for that particular subcommittee. And it doesn't matter what you call it. So you can call it a task force or a work group or a subcommittee. It doesn't matter, as long as it meets those requirements, that it's sort of a mayor or council appointed group, and they're coming back to make recommendations to the council, it qualifies and is subject to the open meeting law. So we talked about public body, and again, it's pretty clear that the city or town, just by statute, is a public body, and may, again, includes advisory or subcommittees that meet that definition. And so that one's kind of a quick yes. So when we're looking at this analysis, yes, you are a public body. So then you have to go to the second step, which is, are you meeting? So we have to look at a quorum and whether you're gathering, and then whether you're taking a legal action. So the gathering in person or through technological devices of a quorum of members of the public body at which they discuss, propose, or take legal action, including any deliberations by a quorum with respect to such action, is essentially the definition of a meeting under the statute. So I kind of broke it down here to, you need your quorum, you need to be gathering, and you need legal action. And if you have all three of those, then you have a meeting. So let's talk first about quorum. We talked a little bit about this, but essentially a quorum is a majority of the full membership of the board or the council, right? So unless you have something, separately in a governing document that says you need a higher threshold or statute requires it, then essentially the quorum is just a majority. I have seen situations with special groups that, let's say you have a subcommittee that you are forming, and for whatever reason you decide, I want to make the quorum, this number. You can certainly put that in the sort of governing documents to as you establish that committee or group. But sometimes that makes it obviously harder if it's not, if it's a much higher number than the majority. So I have seen it, but it's rare. Most just kind of default to the statute, which is the majority of the full membership. And if for your council, that's what you would follow. So how is quorum affected by disqualifications due to conflict of interest? So essentially, if you have a conflict and you decide, okay, yes, I do have a conflict, I can't vote on this issue, so I'm going to declare the conflict and then recuse myself from voting. Again, that means you're losing somebody on the council who could vote. And so how does that impact your ability to move forward? And so a disqualified member cannot be counted for quorum purposes to discuss or decide that particular matter. So I have an example here. So if you have a 5-member board and they have 3 members present, right? That's usually a quorum. But one member has declared a conflict and can't vote on that matter. They cannot proceed on that specific item until another member shows up. And again, it is only isolated to that particular item of which you have a conflict. If you have other agenda items that you can discuss and there is no conflict, you can proceed with sort of like your regular business. But essentially on that issue itself, you're going to have to, if you recuse yourself, then you've lost that person. And this is just based on some case law here in Arizona. So that does impact you moving forward. It obviously becomes more of a problem if you have either kind of these small groups, working groups, who have less sort of people there present anyway, because maybe it's a 5-member group or a 5-member council. Usually with the larger councils, you have a little more flexibility, but it's just something to keep in mind. I also just want to say before we get into splintering the quorum that we do have situations where there's something called the rule of impossibility. And so if for some reason you are maybe in a small town and you do only have 5 council members and there's 2 of you, or maybe, yes, let's say there's 2 of you that have a conflict and you've recused yourself, and then another person is absent and can't be there, but you need to vote on something, there is a mechanism for you to continue to actually vote for those members who've declared the conflict. This is something that would be used very rarely, and you would want to get your legal counsel to assist you with this. But it's called the rule of impossibility. And it's basically trying to say that if you can't sort of proceed in your role and your duties as a government official because of sort of the conflicts or vacancies that have been created, that it kind of allows you to move forward. You still have to disclose the conflict, but you can at least conduct your business. So also there's been questions about vacancies in the past and how vacancies affect your quorum. That is something, unfortunately, that we don't have any guidance. It used to be handled the same way as disqualifications, which means you couldn't count them for quorum. But the Attorney General has removed that guidance from their website a couple of years ago, and there's really no case law on it. So this is, if you have vacancies that are affecting your quorum, I would talk to your attorney just to see about whether or not that impacts you moving forward. Okay, so splintering the quorum. So basically this means separate or serial discussions with majority of the members of the council. So what it basically means is that you're kind of creating almost like a string of separate discussions, but you're having essentially the same discussion. So you could have essentially all of these devices, whether it's email or chat or telephone, or using staff, that maybe let's say a 7-member council, 4 is a quorum. So let's say you have, 2 members that are talking about an issue, and then they get a 3rd member on the phone to talk about that issue. That's fine at this stage, but then let's say that 3rd person then is starting to email a 4th person about what is being discussed. So this is kind of an example of splintering the quorum. So even though you're not all together in person in one room having that discussion, you've now sort of had a serial discussion through different mechanisms, so that now a quorum is essentially gathering and discussing an item that should be coming before the council, and you're in violation of the law. So this is where you just have to be really careful about who you're talking to and making sure that that information isn't getting sort of shared down the line to other council members. And there's a couple other examples here. Polling is essentially where basically you're basically polling. You're going to council member and asking them, what is their position? How are they going to vote on something? And once you get past again that number, that quorum, you've essentially violated the law. Also staff, you can't use staff, to say, well, I can't talk to council members, but I'm going to have the staff go ask, how all the council members are going to vote. Again, it's prohibited in law that you can't direct staff to violate the open meeting law. So this is what splintering the quorum is, and you just want to be careful about it. So when we get a lot of questions about quorums at social events, because, there's a lot of things that you're doing together as a council, but it's not necessarily a council meeting. So a social event is usually some type of function or outing, right? Like it's, a parade or a festival or something like that that's happening in your city or town. So if more than a quorum is going to be present at this social event, you can post a courtesy agenda. It is not required. Some cities and towns prefer to do this because it gives the public notice that, yes, we know that a quorum of the council is going to be present, but they are not going to actually be taking any legal action. So you'd post something that says, this is what the event is, the quorum might be present, and that again, no business of the council is going to be discussed and no actions taken. And the public usually sees, again, if you're at a festival, a parade, anything like that, I think they, kind of take that and they understand it. Um, in some jurisdictions, this isn't helpful just because if you're living in a smaller area where you have either a lot of these events or maybe you're running into each other at, religious services or other types of things where the quorum is going to be together quite often. Again, not to discuss council action, but just because you live in a small community, this can become somewhat cumbersome, for your clerk to constantly have to try to anticipate all the times where the quorum might be present. So it's not required by the law. It's really just something that works best for you. Then you can go ahead and proceed, but you certainly don't have to. So we've talked about sort of the first step of what makes a meeting, and that's the quorum. So let's talk about gathering. So gathering is essentially just that, right? It's just a gathering of people. But there are also, it does include electronic communications. And this is where I think most people tend to, run afoul of the open meeting law inadvertently. I think it's easy to sort of look around when you're in person and say, oh, there's 4 of us here. We can't talk about this. But essentially, electronic communications, you can run into the same issue. So, for purposes of the law, a meeting does include a one-way electronic communication that's sent from one member of the council to a quorum of other members and proposes legal action. So you could essentially have one member of your council violate the open meeting law just by sending all of you an email, or at least a quorum of the members an email, if that email proposes legal action. And we'll talk about the definition of legal action here in a minute, but it's pretty broad. It's discussions, deliberations, anything that might come before the council. If you're proposing legal action, let's say you're like, I think that we should go ahead and file that lawsuit. And you have copied all of the members of the council or a quorum of members of the council. You have just violated the open meeting law. You cannot communicate to a quorum of members in an electronic setting, because that is a gathering, and propose legal action. So this is where people, I think, kind of trip up, again, inadvertently, because we just use email and texting and all of that so easily now. You just have to be very careful about your communications. It also, of course, applies to an exchange of emails back and forth among a quorum of members that, again, discusses, deliberates any type of legal action that might become before the council. But I think people are often surprised to hear that you don't even have to be involved in the exchange, and somehow now the council has violated the law. So often, to sort of avoid this, you want to, not reply all. If you get an email, you want to use staff to be able to kind of facilitate, if they're going to be the ones sending you agenda packets, or they're the ones going to be sending you information. So that way it's not coming from the council and you're not sort of inclined to then start having conversations. So kind of just rely on staff to help you with this and navigate it. So as we talked about, electronic communications is pretty broad in terms of the gathering and having a meeting. So it doesn't matter what type of medium you use. It could be email or text or chat or Zoom or any type of instant messaging. They're all technological devices that the Attorney General has opined and now is codified into law that essentially is included in communications that can be, again, considered a meeting under the open meeting law. So for our meeting criteria, let's see, we have the quorum, we've talked about gathering, so let's talk about legal action. So this is the definition from statute, which to me has not been that helpful. It's just, collective decision, commitment that basically stems from your charter or constitution or the state law and provide sort of the scope of the work that you do. All legal action of councils has to occur at a public meeting. So this next definition is a little more helpful, and this comes from Attorney General opinions. So legal action is essentially any discussion, deliberation, consideration, consultation among your quorum of the council regarding matters that may foreseeably require final action or a final decision by the council. And so when you read that, you can see that it's very broad, right? All discussions, all deliberations, all considerations by a quorum of a matter that might foreseeably come before the council. So really it's anything within the scope of your duties is essentially legal action. So let's talk briefly about social media, because we do get these questions about how does social media fit into this. There is no specific guidance from the state about how to use social media and to be careful, essentially about avoiding open meeting law violations. And so all we have to go on is the current law. And so it's important that you don't use social media to circumvent the open meeting law. But really the analysis that the Attorney General would take would be the same as with any other sort of complaint they received. They'd be asking these questions, right? Are you gathering? Well, social media platforms are electronic communications, and so they do fit into that technological device definition and of a meeting. And so, yes, it is a gathering, right? They would look at, is the gathering, is there a quorum on social media? Well, that's a little more challenging with some of these platforms. But they probably look at whether or not a quorum of the council is following you or are your friends, and what input and interaction sort of level they have with you. Also, they might be looking at whether or not the public can access your community. So there might be a distinction, right? If you have a Facebook page that is just an open page, anybody can like it, anybody can comment. Maybe you share, sort of things that are happening around the city or town, and it's open again to anybody. That might be a different, analysis for the Attorney General than if you have a Facebook group that you've created that only contains members of the council and maybe a few select other people. I think that second situation is going to have a lot more red flags of, well, you're basically creating a quorum of members that you can discuss things offline out of the view of the public that really should be coming before the council. Also, they will be looking at, are you discussing legal action? So are you using the platform to share neutral information? Again, are you just kind of forwarding things that are coming from different, different government groups or agencies, things like that? Or are you actually posting your ideas and how you're going to be voting on certain issues? And then are the council members now commenting on your posts where now you're having that discussion deliberation, and maybe now you have other council members who are seeing that conversation. It's that serial communication that essentially might be occurring. So these are all the things you have to consider. And there really, again, is no guidance, which is unfortunate that we don't have anything. So that's why I would say you have to be very cautious with your communications. Make sure that you're not sort of openly trying to circumvent the open meeting law, that, if you have, certain conversations that they really have nothing to do with your council work. So for instance, if you are following another council member's, social media platform, and they're welcoming a new child to the family, or new baby, something like that, and you're saying congratulations, well, that has nothing to do with the council work, right? That would be fine. If it's something, again, you're talking about holiday decorations and how to make this or make that craft, something like that, it's probably not going to be within the sort of discussions and deliberations of the council, so you're probably going to be okay. But these are the things that you just have to consider moving forward, about if you are sort of friends, or if you have other members of the council on your platform that follow you, about just being very careful about what you comment on, so that you're not, again, sort of running afoul of the open meeting law. So here are just some best practices. I mean, I think the most the safest approach is basically you just don't friend or follow any other members of the council. You just kind of that way that kind of spares you from that social media issue. If you do choose to friend or follow them, I would suggest that you not post anything about obviously your council business or anything related to the city or town, or really just don't comment at all. And then also you don't want to create message groups that include a quorum of the council members. I mean, I think if you did that again, I think that would be pretty easy for the attorney general to come in and say, well, it's clearly a gathering and there's a quorum, and on such and such time you've discussed legal action, and so you violated the law. So these are just things to consider moving forward. And of course, if there's any guidance that's issued, the league will be sure to kind of send that out to anybody. So we've talked a little bit about how the open meeting law applies and whether or not you're a public body, and if there's a quorum, and if you're gathering, and then discussing and taking legal action. So essentially, if the answer is yes to all of these, then the open meeting law applies. So this is just a quick graphic of that. So who can I talk to? This is a question we get a lot. People like, I can't talk to anybody. Well, you can. You just have to be cautious. So you can talk to other council members. Again, you just have to be wary of that quorum, right? So if it's 7-member council, that's 4. 5, then it's 3. So just make sure that you know what the quorum is. You can find a buddy, talk to them about a certain issue. And then you can always talk to a different council member about a different issue. It's really just making sure that there's not that serial communication. So just making sure also you're very careful about electronic communications, and just making sure you don't like forward or reply all again, so that you're inadvertently including quorums on discussions. You can also talk to your staff, including your city town attorney. You can talk to your constituents, and then of course the media as well. And for the press, this was actually codified. So public officials can express their opinion publicly. How I just said, you can't poll and you can't, find out each other's votes, and you want to maybe be careful about that on social media. Well, there is a communications to the press sort of exception here that says, if basically the media is interviewing you or asking you for your opinion on how you're going to vote on something, you can express it. It's not a violation. Again, as long as it's not part of some sort of elaborate plan to avoid the open meeting law. We haven't seen anything like that of that occurring, but it's just something to keep in mind. So you can talk to the media. And part of that reasoning is essentially that you have, if you were talking to the press and they're printing it or they're, relaying that information is public. That's going to get out to the public. And so it's not sort of behind closed doors. So I'm going to kind of move on. Let me see, there's a few quick questions here. I have kind of just some hypotheticals that I created. And so as a 5-member council, basically, can you talk to another member outside a council meeting about an issue that may come before the council? And sorry, my screen's off a little here, so I can't see the whole question, but essentially you just want to make sure that you have to be wary of quorums, and making sure that you actually can you're not talking to more than a quorum of members if it's going to be a legal action that's being taken. So, and then let's say you've talked to, if it's just, again, you talk to one person, then it's essentially fine, right? You can talk to another council member. But if you're a member of sort of 5-member council, and you talk to that member and then you want to go talk to a third member, well, that's where you're running into issues, because then essentially now you have a quorum, right? Your quorum is 3. So you can't have a conversation with that third member about what you already had with that second person. So what about 3 members of a 5-member council attending a conference together? So that's fine, right? That happens a lot. People go on, again, to festivals, parades, to conferences together. That's fine. Again, you just can't have sort of that discussion of any type of action that might be coming before the council. And then can you talk to a reporter? Yes, we covered the media. And then can you post on social media accounts about how you might vote on an upcoming agenda item? And this is where, again, there is no guidance. I would encourage you not to do that. You can certainly argue that it has the same, wait as talking to a member of the press. But if a complaint is filed against you, the attorney general is going to be looking at whether or not you have, if that's open to the public, are you trying to deliberately circumvent the law? So it's just certain things to consider. I think it would probably be best to not share that information on that account. All right, so now we're back to Q&A.
Okay, Christina, we have some questions here. The first question is, while watching several different councils, many contentious items have not been debated or discussed by the sitting council, but rather voted unanimously, either for or against the item. When, from a citizen's perspective, these should have at least been debated. As a normal citizen, it appears that these discussions and decisions are being made by the entire council prior to the meetings. How can this impression of violating the open meeting law, whether accurate or not, be avoided?
Well, I do agree that I think if there is not a lot of discussion or deliberation, that I think that perception certainly occurs. I've seen that as well. However, I think it kind of depends on the issue, because often there's a lot of work study sessions that happen before that. So maybe they've had several discussions, but then at the actual council meeting, you're only, taking a vote essentially because you've already sort of worked through all those discussions and deliberations at other public meetings. And so maybe it's a quick vote. But, I think in matters of whether or not there has been no discussions or deliberations on an issue, I think that raises a lot of eyebrows. Really, the only thing that could happen is a complaint has to be filed with the attorney general. And then at that point, it's just a matter of them investigating. And the AG has access to all your records and your minutes, and they can ask, for your texts, and they can get all this information. So if you have been deliberating behind closed doors, they will likely find out and then issue penalties. So I would say be careful.
Yep. And then kind of a second part to that question is, when it pertains to executive sessions, how should a council conduct themselves when presented with the information or items during the open session, when it has already been discussed and already decided on during those closed executive sessions?
Okay, let's wait till this question, because we're going to talk about e-sessions in a bit. Yeah,
Okay.
so let's try to answer it then, or if Matt, we can go back to it.
Great. The next question is it allowed and or appropriate for a council member to attend advisory committee meetings that are subject to the open meeting law? Can a quorum of the council attend these meetings?
So that's a good question. So I guess I would say that, I think you have to be careful, because if you are going to have a quorum there, I guess sort of what's the point of the subcommittee, right? Or the advisory committee? You're going to get all this information back to you as the council. They're going to do a report, or they're going to come present to you where you can ask questions. It's sort of them letting them do their work. And so if you want to show up and sort of watch them and observe, you might be able to actually just listen to the recording later. I know that a lot of jurisdictions do that to avoid this very issue, to where they don't want the council, obviously, to form a quorum. So then they're actually having to post, you know what I mean? That now there's a possible council meeting, but it's really a subcommittee meeting. So talk to your attorney about it, because there might be some procedures. I know a lot of jurisdictions have started kind of limiting your ability to do that because of this reason. They don't want to run afoul of the open meeting law, but they provide other mechanisms for you to actually watch or view later, or again, to get that information, because they're going to come back to you, to the council, to actually provide all of those recommendations.
Okay, the next question is, what if a mayor, you don't go out and ask the rest of the council to see how they feel about an agenda item, but three of them come up to you voluntarily to let you know? Is that a violation of the open meeting law?
Well, I think once that sort of third, they're essentially having now four individuals who sort of know the same thing, right? So think of it that way. So if three individuals have come up to you and have told you certain things, you know what they're doing, and now you yourself know, what you're going to be voting on. I think it's concerning. I think you want to try to avoid those situations. If someone starts talking kind of down that path, you might want to be like, hey, I've already talked to two people about this, so it's best that I don't know, maybe where you're at, because again, you just don't want to get to a situation of those serial communications. And you certainly don't want to be on the hook as the mayor. The AG has instituted some more severe penalties on individuals now. So you just want to be careful and kind of avoid those situations.
Okay, the next question is, how are discussions or deliberations you've had before you were an elected official with current members of the body on an issue that will come before the body? How is this viewed?
So the open meeting law applies only to you as the council. And then again, sort of if you're gathering and meeting and having that legal action. So if you've had sort of prior discussions before you were elected, um, that was not subject to the open meeting law.
Okay. The next question is, City Council Member A sends an email to City Council Member B and discusses a council issue. Then that Member B sends an email to Member C and they discuss the issue. Then if Member C contacts me, Member D via email, now a quorum has been established. Even if I do not reply back to Member C, but I discover that 4 members have now been involved, should I contact the city attorney and make him aware of the suspected quorum, or should I just not reply to Member C's email and ignore the fact that the open meeting law has possibly been violated?
Mhm. Well, I probably wouldn't reply because again, yeah, you don't want to sort of start conversing. And I do think it's helpful for you to alert your legal counsel because obviously if this becomes, an investigation or violation, I think it's better for them. I have had other cities and towns that have sort of self-reported, or talked to the attorney general's office and said, "Phew, we've inadvertently done this. We've corrected it. These are the measures and steps we've taken to make sure it doesn't happen again." And then typically an investigation isn't sort of launched. So I do think it's important to at least talk with your legal counsel, let them know that you think there might be potential violation, because at the very least, then maybe it just indicates that there needs to be more training and instruction for everybody to avoid the situation in the future.
All right. The next question is, on my Facebook campaign page, which I had posted my platform on various subjects, is now converted to my council member page. Should I remove all my platform positions to avoid open meeting law violations?
So that's an interesting question. We had sort of a social media presenter, I guess it was a year ago now, who kind of talked about this. And we have very little guidance, even nationally, about how some of these social media platforms kind of interact with our state laws. And I remember his suggestion was yes, you know what I mean? Like, or you should have very separate, distinct, if you have your campaign platform, it should be very separate from your, different, social media platform for your council, your elected official. That was his suggestion at the time. I think it was probably a best practice to help you avoid kind of these situations. But again, those were all made sort of prior to you becoming a council member. I think moving forward, I would discourage any type of, let's say someone comments on something that you talked about a few months ago, but now is going to be coming before you as a council member. You probably don't want to comment on that, or maybe you want to remove the ability to comment on those types of feeds. So those are some suggestions, but I think overall it's useful to kind of keep those things separate.
Okay, next question is, if the city manager emails to mayor and council an update on a project and one of the council members inadvertently does a reply all with a simple thank you, is that a violation?
No, I mean, that's just, I mean, you're obviously not kind of weighing in on anything. But again, I would still discourage it, I mean, just only because you'll get into a habit. And so you just want to be careful when you're actually replying that you're only replying back to sort of, that person who sent it to you and not everybody.
Okay, the next question is, can you please address council members talking with town manager or town attorney about subjects that will appear on the agenda?
Okay, well, it's fine for council to, how I mentioned, that who you can talk to, you can certainly talk to staff. So that is perfectly fine for you to have that discussion with them about what's going to be on the agenda. If you have questions ahead of time, there's no restrictions on your ability to talk with the staff.
Okay, the next question is, how long does agendas from the past meetings need to be available to the public?
So I think that has to do with your retention statutes. The State Library and Archives has all that laid out, and so actually your clerk should have that schedule of how long it has to be posted.
Okay. Next question is, in my town, they have not been posting the agenda on the website 24 hours prior to the meetings. When I questioned it, they said it was posted in a physical location, post office, library, town halls. Is this acceptable?
Well, it does have to be posted physically, but it should be posted on the website. So I don't know if you want to just follow up with them and see if maybe it's a technological issue that they're having, but certainly it should be on the website.
Okay. The next question is, when speaking about boards, subcommittees, and other public bodies, you mentioned that if it is something that the council or the mayor requested, it is considered a public body and is subject to the open meeting law. What if a mayor has instructed staff outside of a council meeting to put together a committee? Is this considered a public body and subject to the open meeting law?
Okay, so this is where, no, I mean, it might not be because again, if it's just a staff directed type of committee that, if they're going to make their own recommendations and come back and report, it may be fine. However, this is where you have to be careful because if it looks like you're trying to circumvent the open meeting law by using staff in this manner, then that's where it sort of flags, an investigation to where they're going to look like, should you actually have made this an actual, subcommittee appointed by the council? And why didn't you? And so I think it might raise some questions, I guess. Usually, when it's staff sort of initiated, that's when you're kind of safely outside of the open meeting law issue. So again, if you're concerned about that, or if that's something you want to do, I would talk to your attorney to make sure that you're carefully, making sure you're not violating the law.
Okay. And then the last question is, once elected, but before being sworn in, can I talk to 3 other members of a 7-member board, or is this a violation of the open meeting law?
Yeah, so I wouldn't, only because again, if you're already elected, you're not a candidate anymore. You're actually elected to the seat, and you're going to be talking about issues that are foreseeably coming before you with a quorum. I haven't seen where there's anything specific from the Attorney General on this issue, but I mean, I feel like you would be in dangerous waters. So I would probably try to avoid that and just follow the same thing you would do once you're sworn in, which is, you can talk to people like less than a quorum, or you can rely on staff.
Okay, there's actually one more question that just came in. If a notice of regular meetings for council and subcommittees are posted for the year, do you have to physically post the agenda, or is the website sufficient?
So you do always have to have the physical locations as well. Yes. So it's supposed to be both. Yeah.
Okay, those are the questions that we have for this part.
Okay, great. Well, we'll try to go through this next part. Should be fairly, hopefully, quick here. It's just essentially how does the law apply now to you? So we know that the open meeting law applies as a public body, that you are in a meeting if you're gathering with a quorum and taking legal action. And so this is sort of your council meeting map of what the steps are required. So your pre-meeting requirements is you have your disclosure statement. It tells the public where all of your other notices are going to be posted. Then you also have your notice of each individual meeting that goes to your members and the public, and then you have your agenda. So notices generally, obviously, are just to make it possible for the public to attend. It informs them of what actually you're going to be discussing, and then provides a mechanism for them to know how to access information about the meeting. So notices are a 2-step process. You have your disclosure statement. It tells the public where all the meeting notices, again, are going to be posted. And then you have your individual notice for each meeting. So your disclosure has to be conspicuously posted, identifying, again, the physical and electronic locations where all your public notices are going to be displayed. The public has to have reasonable access to this notification location, right? It can't be sort of indoors on the 3rd floor in an area that's badged only, so the public can't access it. It needs to be somewhere like in the lobby or maybe outside, somewhere where the public can see it. Normal business hours is fine. And then public bodies and town, they do have to post this information on their own websites. This is in state law, so I know that was one of the questions. It does have to be posted. online. And then meeting notices, you basically just can, date, time, place of meeting, just where basically the meeting will be held. The public notice of the meeting. So this can include the agenda, which I think a lot of people do, or at least has to tell the public where they can obtain the agenda. Because maybe sometimes the notice is being put out like a week ahead of time, but the agenda will be out a couple days later. So notices have to be posted again on the website and then in all of the locations that were identified in the disclosure statement. And then you can always provide additional notice. So if you have, the public TV or public access, any types of newsletters, anything like that, you can always kind of say, hey, here are our scheduled meetings for the year. There are 3 exceptions because all of these notice requirements have to be put up within 24 hours before the meeting. And there's 3 exceptions to that requirement. So one is an actual emergency. So it has to be emergencies occurring to where now you're going to be holding a meeting less than 24 hours before you posted that notice. And so you still have to post the notice, but obviously it's not going to make that 24-hour deadline. Also, you can recess and reconvene a meeting. So let's say you properly posted your notice and your agenda, well before the 24 hours, you're holding your meeting, but maybe it's going a little longer than you expected and you can see that it needs to go even longer. You can recess that meeting without having to post a new notice as long as you actually announce the time and place when you're going to resume the notice or the meeting. So that's another option for you. Also, ratification of a prior legal action. This actually requires that if you violated the open meeting law and you actually have to ratify an action that you took in violation, your posting is actually now required 72 hours before the meeting instead of 24. And so this was actually a little bit more. So also there is a one-time public notice if you want to go ahead and post that. And that's if you actually have, let's say your meetings are on the same sort of regular, day, date, time, all of that. You don't deviate from it. And so instead of having to post notices every week, you can then go ahead and post just sort of one notice that's basically specifies that your meetings are on this day at this time at this location. But you do have to post at least where you're going to find your agenda. But that does kind of save you some time in terms of the notice. So for agendas, same thing, kind of similar as the notice. It's time, date, place of meeting. And then you have to list the specific matters to be discussed, considered, or decided. So again, action can only be taken on items that are listed on the agenda. If you talk about items not listed, it is an open meeting law violation. And so just be aware of that. And if you have questions, as you're looking at an agenda of whether you can raise, certain issues within it, because maybe you're not sure, talk to staff ahead of time and ask. And then agendas must contain information that's reasonably necessary to inform the public of the matters to be discussed or decided. So this means that you can't just sort of throw up a statute and say, we're going to talk about this, pursuant to, and you put a statute number. That's not helpful to anybody. Or if you say, we're going to annex some land, well, you need to provide a little bit of information about what land are you going to annex or what's the issue that's going to be discussed. So again, if there's any doubt, all questions have to be resolved in favor of greater disclosure of information. So here's some agenda writing pitfalls. Again, you just don't want to use generic terms like personnel or new business, old business. That's not specific enough. Also executive session items. We'll talk about executive session in a moment. But, again, you can't just list the statutory authorization for why you're going into an executive session. You actually need to, again, sort of provide at least a small general description of what you're discussing. So you can't just list a statute, but you might want to say personnel review of the manager. That's a lot more helpful to the public than just a statutory citation. Current events, you can have these, but essentially current events is really supposed to be a one-way summary from the presiding officer, or the mayor or something like that, to provide like a current event update, basically. It's a one-way communication. So if you have an item that's included in the current events and you as a council member are going to want to actually ask questions or talk about it, then you need to see what procedures you need to follow to get that removed from that event agenda, or to actually put it as a separate agenda item. so that way you can have a discussion. Because current events are really, again, one-way communication. It's just about that person presenting the information to you, no further discussion allowed. Consent agendas, again, are just really designed for sort of non-controversial items where kind of in bulk, you're going to just be making sort of a mass motion. You do still have to identify on the agenda just what it is you're going to be voting on, but essentially they're very helpful in terms of kind of time savers. So other pitfalls, what if you fail to properly list an item that the council is planning to discuss? Well, you can't discuss it. You don't want to go down the route of talking about it, having a violation, and then basically voiding your discussion or your contract or whatever action you took. And then what if a board member begins speaking on a topic item that's not listed on the agenda? Well, this is where you need to help each other, kind of gently and remind them like, oh, this is not on the agenda. Maybe we can put it on next week's agenda. And then you also want to just kind of instruct them, especially if you're the chair, you might want to instruct them to cease discussion on that topic. And then what happens if you take legal action on an item not listed on the agenda? Well, again, that's a violation. The item is null and void, and then you can also face sanctions by the Attorney General. So a couple scenarios. Can a notice be posted at a location not listed on the disclosure statement? Yes, but it still has to be posted at all the places that you noted in the disclosure statement. So you can always give more notice, but it can't substitute for a location that's listed in the disclosure statement. And can the council post one notice sort of for all of its meetings if held on different dates and times? And the answer is no, right? The statute only allows you to use that sort of one notice posting if it's going to be the meetings are on the same dates and times and locations. So can a council member discuss or motion to vote on a matter not listed on the agenda? That's no, right? You can't talk about anything that's not on the agenda. Can a staff member other than the administrator provide a current event summary? So we do have, some people have tried to use the current event summary provision as a mechanism to have these sort of reports from different departments. Really, the statute's pretty narrow about who can actually provide that summary. It's really only the council themselves and then the manager. So if you want to have another report from a different department, that's absolutely fine. You just need to put that on as a separate agenda item and just list it there as sort of department review or department update on whatever the issue is. You just can't kind of lob it under the current event summary. And then can another council member ask questions about the current event summary? Again, no, this is supposed to be a one-way discussion, or I'm sorry, not even a discussion, just a one-way communication. So if you have, again, you see the agenda and you're like, oh, I'm going to want to ask about this. If you have the ability to maybe amend the agenda ahead of time to say, can we maybe create a separate agenda item for this topic? That's great. If not, maybe you can ask for that to be on the next agenda so you can discuss it more fully. So at the meeting, again, you want to determine your quorum, record all the members present, absent, adopt your minutes, look at your agenda. It's okay to change the order of the items themselves as long as it's listed on the agenda. Maybe you see that there's a lot of speakers, members of the public who want to speak on item 5. And so you want to maybe move that to the top so you can kind of help facilitate that exchange and help them. So you can certainly do that, but you want to announce it. And then you also want to record your motions and voting. So at the meeting, like public access, we've talked about this a little bit. So the council does have to provide the public with access to all meetings. They have the right to attend and listen to the deliberations. Council can't obstruct or inhibit attendance anyway. So you can't require them to have to sign in just to be present there. You can't hold the meeting in such a remote location where it would be difficult for them to access. And that goes along with also, like, let's say you're having a council retreat. Well, it's still subject to the open meeting law, and it's okay that you're in a different location, but it can't be at a clubhouse that's in a gated community that the public can't access, right? There's going to have to be a mechanism for the public to be able to, again, listen and attend that hearing. Also, you don't want to have meetings at such an unreasonable time where, people are likely not going to show up. So at the meeting, the call to the public, again, this is not required. But if you do allow a call to the public, and most of our cities and towns do, you do have to kind of follow these guidelines or these requirements. So, you can have a time limit. You just have to apply it uniformly. You want to make sure that anybody who's speaking, a member of the public, that they're actually talking about issues that are in the city or town, so that they're not actually, if they start talking to you about issues like federal issues, you can politely let them know that that's not within the jurisdiction, and that hopefully you can kind of steer them back into city or town issues. Sometimes it's easier just to let them finish talking, but certainly they're supposed to just be talking about items within the jurisdiction. And then sign in when somebody actually is during the call to the public, you can ask them to at least identify themselves for the record. So at the meeting, remote conferencing has become much more in use these days after COVID. So is it allowed? You need to check with your city or town. There is no state law restriction, but there are some in some cities and towns. They might have lifted those now because of the pandemic, but sometimes there were limits on how often you could do it or whether you could do it at all. So I would just double check to make sure. Again, I think most have allowed it at this stage. But if you do have remote conferencing by phone or Zoom, anything like that, the public has to be able to hear you. The person on the phone, let's say, or on Zoom or WebEx, whatever it might be, has to be able to hear everybody else. And then participation has to be noted on the agenda and reflected in the minutes that that person was a remote conference attendee. So there has been a recent Attorney General opinion on this remote conferencing because of the pandemic. So specific to regular meetings, essentially, they wanted to provide some best practices of kind of how to go through this. And so they basically said, if you're in a remote conference, you have to post a statement on the city or town website, letting them know sort of how to access remotely, but also a means of getting some tech support if they were having trouble. And then provide that location about, again, directions about how to access the meeting or that conference call number. And then also they essentially want, members of the council, staff, anyone who's presenting, and even members of the public to identify themselves each time they begin speaking. Again, this is kind of for the record, and it can be very difficult, especially on phone conferencing. You don't know who's talking. To let them know for, again, for the minutes, to let them know who is saying what. And then you want to include copies of presentations, documents, anything like that you want to make accessible on the website that are going to be related to the meeting. Most cities and towns already do that with their agenda packets. And then ask all participants, of course, to ensure their microphones and phones are muted or that they're not speaking, they don't put you on hold. If you can record the meeting, I think it's helpful. Obviously, then people can go back and look later. And then you just want to take any other sort of steps necessary to make sure that the meeting is public and open. So meeting pitfalls, you don't want to be whispering to or texting fellow members when you're on the dais. The public can tell. They can tell when you're having sort of side conversations, and they immediately just, basically believe that you are talking about things that are right before you at that moment and that you might be violating the law. So you just want to be careful. Also be careful about talking to a quorum of members before the meeting officially starts. This is a thing that sort of happens, as you're waiting for the meeting to start, people are sort of coming in. Maybe you're talking to a couple people, members of the public, but then a couple other members of council members join you, and all of a sudden now you have a quorum and you're talking about an issue that you're going to be talking about in a few moments in the meeting. So just, again, be wary of the quorum around you. And then just engaging in discussion with speakers during the call to the public. You can't do that. Essentially, for the call to the public, it's really kind of that one-way communication. Where they are, providing you their comments. It's not meant to be a discussion with them or a conversation. And that actually can be frustrating to the member of the public sometimes. They feel like you're not hearing them. And so it's helpful in the beginning to kind of, right before the call of the public, to let them know we are restricted by state law. We're not able to respond to any of your comments today. Again, there's a couple exceptions to that, but I think that helps sort of smooth it out so the public feels that, or they understand that it's not really that you're refusing to engage with them, but it's mostly a state law restriction. And then also other meeting pitfalls, just poor reception. Obviously, if you can't hear someone on the phone or on the web, that it can be make sure that you're trying to get that fixed as soon as possible, or maybe move to a different item until that gets resolved. So let's talk briefly about the executive sessions. So again, we've been talking about open meeting law. Everything has to be done in public, nothing in secret. Well, there is one exception to that, and that's executive sessions. So this is a gathering of the quorum of the members that excludes the public, essentially. You can meet privately, but there are only limited exceptions to how you can use this. You do have to take the vote to go into executive session in public. So you go ahead and make that motion, someone seconds it, you take the vote, and then you all move into executive session, or essentially maybe, remove the public from the room, however you do it. The agenda has to state the specific provision of law authorizing the e-session and specify that item. Again, some general description. It can't just use a statutory authorization. And then who attends the meetings, basically, or the e-sessions. It's only members of the council, and then persons who are sort of necessary to be there, right? So you might need your clerk there, or if you're getting legal advice, it might be your attorney. Or if you're talking about a land issue and maybe you need that department head there. So again, just people who are reasonably necessary for the council to actually facilitate that e-session. And then also, if you're doing a personnel review, that person is entitled to be there as well. And then the auditor general, this is very rarely used. And this is, again, if you were discussing something related to an audit, they have the right to be there. You do still have to essentially take, again, the clerk has to take minutes, the attorney, if they're there to give legal advice. It's helpful if you have people other than the council at the e-session that why certain staff are necessary, because you do take minutes for the e-session. And if you get a complaint and there's an investigation, it's already there basically for the attorney general to review of why those individuals were present. So again, moving into executive session, that has to be done in a public meeting. You just want to make sure the room is clear. There's no recording devices left behind. And this is very important. Once you are in e-session, all those that are in attendance have to be reminded that discussions are confidential. So there's 7 reasons why you can go into an executive session. So again, these are seen very narrowly by the courts and the Attorney General's office, so you don't want to abuse them. So the first we kind of touched on was personnel matters. If you're talking about hiring or firing or promoting or anything like that relating to a city or town employee, then you can go into e-session to discuss. The second is if you're talking about confidential records themselves. So you can't obviously have a public discussion about something that's been deemed confidential, which sometimes happens. Federal law might have direct that certain things are confidential. There's also a list in the Attorney General's handbook of all of the state documents that are confidential. So if you're talking about any of those, then it would you could go into e-session. And then also discussion or consultation for legal advice with the attorney. So if you're getting legal advice, then you can use this purpose to go ahead and go into e-session. And then discussion or consultation with attorneys to consider or instruct regarding contract negotiations. And so again, this is like if you're having settlement or litigation, you can go ahead and use this option. Then there's also other discussions or consultations with employee organizations for negotiating salaries. That's an e-session provision. Other discussions with international or tribal negotiations, or again, if you're going to be sort of instructing on negotiations for purchase, sale, or lease of a real property. And then just quickly, there's been 2 new purposes that were added just this year. And so this has to do with kind of like the security of the city or town. And number 9 here was actually a league resolution. we essentially had a city that brought forward an issue that they wanted to do some sort of security assessments and have discussions about what to do and sort of like active shooter situations, et cetera. But they didn't want to have obviously these discussions in public. That would sort of defeat the purpose if you're talking about what the strategies will be and how to respond. And so they found that there really wasn't a mechanism in statute to allow for these meetings to happen, privately. So this was something that was passed this year. The first one here, number 8, is pretty much similar, but it just relates specifically to school safety operations. So they can have those, school safety discussions and plans and programs in an e-session. And then number 9 is more applicable to cities and towns, where we can have those discussions, procedures, assessments relating to the safety, security of buildings and other public facilities in an executive session. So these 2 are brand new this year. So at the meeting again for e-session, minutes and discussions are confidential. The members of the public body obviously can participate, and they can actually see minutes and the materials that were discussed, but no member of the public should see it, as well as members of the council shouldn't be having discussions about what was discussed in e-session with anybody outside of e-session. So at the meeting, some e-session pitfalls, of course, failure to keep information confidential, failure to advise persons about the confidentiality requirement. It's usually the chairman or so the mayor would kind of just put that reminder out beginning of e-session. And then also best practices for preserving confidentiality. You just want to make sure that if you have materials that are specific to that e-session, that they get collected by the clerk or whoever it is to make sure they're not sort of left behind to be found by someone else later. So a couple hypotheticals. Can the council only list the statutory authorization for e-session? So the answer is no, right? You do have to provide some general description of what you're going to be talking about. And this can become challenging because obviously you're going into e-session to talk about something that you wouldn't talk about openly. So, work with your attorney on the best, language for that provision. And then are e-session minutes available to the public? No, they are not, although the AG can review them in an investigation. Can a council member who was absent from the meeting review the e-session minutes? Yes, they are a member of that council. And even though they weren't present at the e-session, they can have access to those meeting minutes in e-session. And then can the council take a vote in e-session? And the answer is no. No legal action can actually be taken in executive session. So you will not be voting. If you have to vote on a matter, then you move back into public session. Okay, I think we're at the Q&A.
Okay, Christina. So we'll go back to that one session. It said, when it pertains to executive sessions, how should a council conduct themselves when presented with information items during an open session, when it has been discussed and already decided on during those closed sessions?
Okay, I'll try to see if I can answer this. So if you've had some e-session discussions on a matter, and then again, those are confidential. But if you have the item on the agenda in public, you can then have more discussions and deliberations. You're just not supposed to disclose anything that occurred in e-session. I guess if you are kind of hearing things and that maybe were discussed in e-session and you're concerned that things are being disclosed, that it might be a violation, I would suggest chatting with your attorney to see if whether or not that is in fact a violation, or maybe if there is, again, you can freely discuss the issues again in an open public meeting. You're just not supposed to discuss sort of like what exactly occurred in the e-session. Most of the time, I think people come out of e-session and then they kind of give a motion and then they make the vote. So that's a little bit tricky. And I think your attorney is going to kind of have to help you navigate that situation.
Okay. Next question is, can a council discuss an item not on the agenda as long as it does not take action? Can it direct staff to research and bring it back for a future meeting?
So the only way, if it's not on the agenda, then you can't discuss it at all. But there is a mechanism for the call to the public if they are bringing up an issue that you could say, you know what, can we maybe put that item on the next agenda? And that's fine. That's one of the exceptions.
Okay. How can you remove an item from the consent agenda and get it into the discussion?
So that's just a procedural rule that you're going to have to check with your clerk or your manager, because it may differ in different jurisdictions, to basically ask, if that's something I've seen it done at the actual council meetings themselves, where you can motion to do it. Other times it requires, something ahead of time. And then other jurisdictions, it might not be allowed. So that's more of a procedural issue that you need to check with your city or town.
Okay, I think this next question is kind of ancillary to that. How can you amend an agenda? You have to do it within a certain amount of time in advance.
Right. So again, it's, the state law only basically talks about the agenda has to be posted 24 hours before the meeting. So any amendments would have to be done before that 24-hour period. But in terms of the actual process, it varies in every jurisdiction. So you have to check.
Okay. The next question is a town nonprofit subject to the open meeting law?
So it depends, again, sort of how they were created. And then I only highlighted the definition that a city or town obviously is a public body, but there is a lengthier definition in there. And so depending on how they're structured, they may fit into the definition of public body.
All right. The next question is it an open meeting law violation if the town council goes into executive session for legal counsel, but uses the executive session to also discuss, debate an agenda item in detail?
Sure. So as I said, the AG and the case law has said that you really have to apply the e-session provisions narrowly. So when you're in there to get legal advice, it really should only be for legal advice. You can't talk about policy. You can't talk about pros and cons or whether or not you should do something. It's really just for you to get, the information from your attorney about how to take action. So yes, it should be very narrow, and you don't want to sort of expand into other issues that could be a violation.
All right. Next question is your 7-member council's quorum of 4 members is present. And then at a meeting, only with 4 members present, at the call to the public, one of the 4 council members gets down from the dais to speak at the call to the public. Now that leaves only 3 seated council members on the dais. Must the meeting end because of a lack of quorum, or is there still a quorum because the 4th member is in the chamber?
So that's a good question. I mean, typically, what I've seen in other situations is, if the person's kind of been present, they might allow, you know what I mean, that to be considered quorum. But if they're actually sort of changing roles, I mean, if you're a council member, then your role is as the council member. You shouldn't then sort of becoming a member of the public, because you're really not. You know what I mean? You're a council member, and so you have the ability to speak anytime. You're not limited under that call of the public. So for quorum purposes, I mean, you do still have a quorum. I guess maybe the secondary issue is I'm not sure whether or not it's appropriate for you to become, you know what I mean, to do a call to the public when you actually have the ability to speak from the dais.
Okay. Next question is, once the council moves from an executive session back to the regular session, can details from the executive session be discussed and reiterated in the regular open session in order to support transparency with the public before motions are made and voted on?
So I think you as an individual council member, if you want to, share for yourself what you've stated or what, like, hey, this is why I believe, we should make this, this is why I'm voting on this, that type of thing, that's fine. But you can't, again, start disclosing what other people have said, or again, any confidential material. Again, typically it seems that most people understand how these e-sessions work. And so you kind of come out of it, you make a general motion, and from there they tend to glean what exactly occurred, by the motion. And then you take the vote. So again, if you're going to be sharing how you feel and why you're voting a certain way, you certainly have the right to speak, but you can't disclose anything else from that e-session.
Okay, this is a kind of a 2-part question. What do you suggest for a member of the council if during the call to the public, another council member responds especially if it is a chairman, mayor of the meeting? And then and this is the second part of the question, what if another council member takes offense to what is said during the call to the public and begins to get into an argument with the person speaking and subsequently has that person removed from the meeting?
Okay. So I'm sorry, Matt, the first question, part of the question was,
What do you suggest for a member of the council if during the call to the public another council member responds, especially if it is the chairman, mayor of the meeting?
okay. Well, okay. So I guess I would just say, to reiterate, the call to the public is really, again, the time for the public to speak, right? It's not really for the council. And you are restricted. You can respond to criticism of you personally. So if someone is talking directly at you, a member of the public is lobbing criticism at you, you can respond. I encourage you not to. I think it's better to not engage. But if you can, in that isolated instance, respond back to them. I think it then just sort of can grow, though, into that sort of back and forth, which you're not allowed to do. So at some point you're going to have to stop. So it's best maybe not to do it at all. I think if somebody else is, I guess, starting to get combative maybe with another member of the public, again, you guys are all together on the council, I think, try to be there to help each other. And so to try to maybe, again, sort of gently remind them of, maybe we can talk about this issue at a later date, on a next agenda item, something like that, to try to, divert or calm the situation. But essentially, it kind of goes back to sort of an earlier reference. You can't sort of be responsible for the behavior of others. I think that it might indicate that more training is needed. And it's something you can talk about sort of later with manager or your attorney or anything like that, to say, hey, maybe we need a little bit more instruction about decorum and how to interact and making sure we're not running afoul of the open meeting law. But those situations do occur, I know, and they're very uncomfortable and they're sort of hard to manage. But you just have to remember sort of what the purpose of the call to the public is, and it's really their time to speak to you.
Okay. This question is, can you go over once again the difference between postponing an item versus tabling it?
Okay, I think it depends on the motion that you use, basically. I mean, if you're postponing, it is essentially is tabling. There's different types of tabling. If you're tabling indefinitely, usually it means you're trying to kill it. So some of this is sort of the vernacular, and that's why I would just suggest, because I've seen some of the city and town procedures, and they're very helpful because I think they kind of break down into more layman's terms about the types of motions. So don't get too tripped up on sort of the tabling or the postponing. It's pretty much the same thing.
Okay. The next question is, if a member of the public shares incorrect information during calls to the public, how do you recommend it be addressed to comply with the recommendation to not respond?
So there's really not much you can do. Again, if you want to have a discussion or deliberation on something they've mentioned, the only option you have is to ask for it to be placed on an agenda for the next meeting. That is your option. Again, unless they're directly criticizing you, it's not something that you can discuss with them. It's not supposed to be about back and forth.
All right. Next question is, if a council discusses a proposal for sale of city property in executive sessions and by consent directs staff to continue discussions with the proposed, must that direction of staff be voted on in the regular session when it resumes?
So no, so that particular provision actually allows for you to give sort of that instruction to your staff, and so in e-session, so it's not required to then go out and do a vote, and part of that is because inherently those types of sort of negotiations or settlements or anything like that are somewhat confidential, right? You don't necessarily, you know, publicize that information because that kind of hurts your negotiating authority. So the instruction for that particular executive session provision, it's kind of embedded in there that if you've given instruction that they can go forward, you don't need to do anything outside of the e-session. I would say though, to make sure that you are clear about the instruction you're giving. Sometimes it's pretty clear that there's a consensus that they're against a certain item, but they don't give clear instruction to the actual staff member. So just make sure there is something, instruction given so that they know how to move forward.
Great. Well, that's the end of the questions, Christina. So I just want to, one just popped up. Uh, what recourse does a council member have from being harassed by a citizen, both at council meetings and in the public?
What recourse do they have? Well, gosh, I mean, I think it depends on the type of harassment. I mean, if you're talking about, um, something that rises to a level of criminal activity, then obviously you can talk to, law enforcement, but rely on your staff as well. I think they've been there for a while and they've kind of seen a lot of things. And so they might be able to kind of help you navigate, that situation going forward. It's certainly, again, uncomfortable and something you don't want to have to deal with, but it kind of depends. I think it's more kind of like a fact intensive question. Yeah.
All right. Well,
I was
again, Christina,
Oh, I
pardon?
was gonna say, I know because I have some other slides, but I know we're out of time. So I just wanted to say, take a look at them. And then if you have any questions, it's mostly just about the Attorney General investigation. And they do take a pretty hard stance against cities and towns. So I just want you to be aware that there are penalties in there against individuals and council members. And so you just want to be careful, but certainly feel free to contact me if you have other questions.
Excellent. Yeah, so please take a look at those other slides. And as Christina said, yeah, you can either contact Christina at her office, or you can also contact the league if you have more questions. And as we've mentioned many times during these trainings already, always consult with your city or town attorney with these types of questions too. This is a lot of information, and it's really meant to just provide you a baseline structure. We realize not everybody's going to fully digest all this information, so it's really just to give you some of the tools that you need. But as Christina mentioned, your staff is your resource. And then a question just came up about how do we contact Christina. It's on the slides, and your slides have been sent to everybody. We'll resend those when we send the videos, but it is on her last slide. So you can get Christina's contact info there, or you can email us at league@azleague.org and we can send you that information also. So with that, Christina, thank you very much for your time and for your knowledge. We appreciate all you've done, and we again feel free to bring any questions to us at the league or Christina. It's on her slides, and we thank all of you for participating. And we'll see you at 1 o'clock for public service ethics, staying out of hot water. Have a great lunchtime, and we'll see you all shortly. Thank you, Christina.